Hi, everyone. This is Dave Stouts. I'm a partner in Husch Blackwell and co-leader of Husch Blackwell's data privacy and cybersecurity practice. I'd like to first thank you for joining us today. Second, introduce you to my co-panelists today. First is Bob Bowman, also a partner at Husch Blackwell. And with us here is also Lauren Cabral, an associate with the firm, and Ephraim Hintz, an associate with the firm. You'll be hearing from all of us today. Again, we appreciate you joining us. I think this is a very timely and, given by the number of RSVPs we've seen, a very relevant topic for a number of companies right now. Before I begin, just sort of get some housekeeping items off my plate. First, you have a question and answer prompt at the bottom of your screen. Feel free to ask as many questions as you want. The reality is, and I think for those of you who attended our prior webinars, is we try to jam-pack as much information as possible into this hour-long program. If we cannot answer your question, we will follow up with you afterwards, shoot you an email with an answer to your question. So feel free to ask as many questions as you want, and we'll get to them as quickly as possible afterwards. Second, there's a resource list icon at the bottom of your screen. That has the slideshow presentation in it. We often get requests after webinars to send the slideshow. You can grab that now. If you're looking for CLE credit, there's prompts on your screen to obtain CLE credit and provide information there to get that. And finally, before I actually get through this and get to our program today, the webinar recording will be available afterwards. We send out an email to everyone who's attended and not attended with a link to the recording. So if for some reason you really want to listen to us again down the line, you will have that ability to do so. Great. Okay. Well, let's get started then, and start with this. I always like to start with a roadmap so you guys can see exactly where we're going. And not a ton of surprise here. We're going to start with a summary of just sort of an overview of what happened. Then we'll talk about what changed, we'll talk about what didn't change, and then we'll talk about what comes next. Okay, so the summary section. We have been, for the past 4 months, tracking 19 bills that would amend or supplement the CCPA. When I say, supplement, there's a number of bills, and we'll talk about one in particular, 1202, the data broker bill, that wouldn't directly amend the CCPA, but clearly were related to it, and the data breach notification statute one as well fits into that category. In any event, of those 19 that we've been tracking, 12 of those bills died. 7 of those bills eventually passed the legislature by last Friday, which was the cutoff. Having said that, some of the concepts of those bills that died made it into the 7 that passed. And we'll be obviously hitting that along the line here. So I want to kind of give a thumbnail sketch of how this all sort of shook out at the last minute. Assembly Bill 1355 became the omnibus bill. And what I mean by that is that bill had crossover with these other bills, 25874, 1146, and 1564. This became very complicated towards the end. And anyone who's tried to look at this legislation has probably really been scratching their head. I mean, if you pull up Assembly Bill 1355 on the legislature's website, you will see in there that it has 3 different versions of 3 or 4 different sections. So, the section 140, there's actually like 3 or 4 different sections and 3 or 4 different iterations, all of which sort of conflict with one another. The reason why we believe that happened is the amendment process was required to be finalized 3 days before they voted on the legislation. Because of that, they essentially created a situation in which 1355 would be the omnibus bill, and it would incorporate these other revisions and these other bills that we have here. And if one of those bills didn't pass the legislature, that stuff would essentially drop out of the omnibus bill. Everything passed. All of these bills that are on your screen, 25874, 1146, et cetera, they passed. The last shoe to drop will then be the governor signing these bills. But we're going to discuss all the provisions that passed. What I'll say to you is, if you're trying to find the text of the legislation, you want to dig into it, 1355 is really the bill that you need to be looking at. And in particular, you're going to be looking at specific provisions in that bill. If that's relevant to you, if you're going to wrestle with the text, just shoot me an email. I'll be happy to get you the provisions of the bills that are operative there. In addition to talking about those, we're going to talk about 1130. That's the bill that amended the data breach notification statute, and 1202. That's the data broker statute that legislation that's gotten a lot of press over the last couple of days. What I will say is what we are not going to talk about is this is not going to be an overview of the CCPA. This is intended to be talking about the things that changed last Friday. If you are looking for an overview of the CCPA, good news, we have plenty of resources to provide that to you. If you go to hushblackwell.com/CCPA, that is our landing page that has tons of resources. It has a guidebook on the CCPA, other webinars we've done, a link to our blog, which tracks all these things, and third-party articles as well. Okay? All right, then let's segue into talking about what changed, and in particular, notable provisions that changed of the bill. And I will turn it over first to Bob, who's going to walk through the personal information definition changes.
Good afternoon or good morning to you all. This is Bob Bowman, partner here at Husch Blackwell. So one of the main items that changed in the amendment is the definition of personal information. So what they added a reasonably to the definition. Essentially, personal information now means information that identifies, relates to, describes, or is reasonably capable of being associated with a particular consumer or household. So what this does is, a lot of you know that data in itself, an obscure data point could possibly be capable of associating with a particular consumer. They added reasonably to qualify this a little bit, to put at least some reasonable bounds around what would be considered personal information under the statute. Still doesn't make it super clear, but at least it narrows it a little bit. It also clarified that personal information does not include de-identified or aggregate consumer information. There was a typo in the original statute, and so this amendment really just changed what all of us thought was going to be the rule, or what the intent of the provision was. Another thing that changed was publicly available is now defined as information that is lawfully made available from federal, state, or local government records. Under the original statute, it required that your use of that data was consistent with the basis upon which the government made that data available. They took that additional condition away as to what you could rely on as publicly available. So if you can get that information from government records, then it would be exempt from the definition of personal information under the statute. I'm going to turn it back over to Dave to talk about another additional exemption that was added.
Yeah, thanks, Bob. And before we turn the page on this one, it's just to give you a general takeaway. These are all perceived to be pro-business provisions to the CCPA, the definition of personal information. Another important amendment that was included is the employee information exemption. This has been discussed for some time, and essentially the takeaway here is that it is the California consumer and not the California Employee Act, right? So the concept here is to carve out employee information from the contours of the CCPA. There are some definitions here that it applies to PI collected in the course of acting as all of those categories: job applicant, employee, owner, director, etc. These are defined terms in the amendments. You're going to want to take a look at those defined terms if you have California employees, and figuring out how to apply those to your CCPA compliance activities. But by and large, the takeaway here is This is intended to be an employee carve-out provision. It has to be, though, the PI here has to be used solely within those contexts, right? If there's overflow, it's not going to apply to that information. And there's also second and third categories for emergency contact information and for the business to retain to administer benefits. There are limitations. This exemption does not apply to the duty to inform as to categories of PI being collected and the purposes for which PI is used. This is an issue. I think this is going to create some sort of compliance headaches for entities as to how exactly to go about providing notice to employees as to the information that's collected and how it's used. I mean, listen, frankly, some of this becomes sort of nonsensical in the sense that if you're having employees fill out forms requesting personal information, they know what information they're asking to be provided, right? But I think it ends up being, the purposes for which the PI is used becomes the tail wagging the dog on this issue here and clear understandings. I think what this is going to roll into is providing, one-page or two-pager notices to employees of privacy practices for the company, internal privacy policies and the like. The second exemption here is it does not apply to the private right of action. Ephraim's going to talk about the expansion of that provision a little bit later, but just keep in mind that your employees, if their information is lost, their personal information is lost as that's defined in private right of action, this is not going to exempt them from pursuing that. And you've got 1 year. There's a 1 year sunset provision involved with this. So you've got a whole 1 year of dealing with this, and then we'll have to wait and see how this shakes out next year and to see if there's any amendments to it. And I say it's a sunset provision, so keep in mind it goes away after 1 year. It's not as though if they do nothing, then it goes away. They're going to have to agree to keep this going. Okay, let me turn it back over to Bob to talk about another important exemption that they got in the business-to-business.
Yeah, kind of an unexpected addition to the bill for those tracking the bill was this addition of a very business-friendly term, and that business-to-business, some personal information collected in a business-to-business context is exempt from the CCPA. Some of the conditions are must be an employee, owner, director, officer, or contractor of company, and really exercising duties, in a professional or business capacity. And then the communication or transaction must occur solely within the context of due diligence regarding or providing or receiving a product or service. So, and like the employee exemption, this does not, there are some exceptions to this. It doesn't apply to the right to opt out of sales of personal information. So even though you're collecting, business contact information, and to the extent you're selling that, which most people probably do not, but you would still have to provide that opt out. It doesn't apply to the Anti-discrimination Provision, and we'll discuss that a little bit more. And then non-business related personal information. And I kind of flagged this because I deal in the e-commerce realm a lot, and notice even if you provide a web portal for business to business transactions, there's usually additional information that's collected, IP address, some of the other things that are to still fall under the definition of personal information that would not be exempted. And then similar to the employee exemption, this is also applied to a 1 year sunset provision. So kind of, one of the things that we're trying to distill is what effect and how we advise our clients. And typically, because this is an exemption, we might treat it like the other GLBA or HIPAA exemptions, where we want to catalog that you're collecting this data and then apply the exemption as applicable, particularly in view of the sunset provision or the possibility that this is changed, next year's legislature, which seems to be the reason for these 1 year sunsets, is to allow a little further negotiation and for businesses and privacy rights activists to reach some sort of compromise on how this data is treated. Now I'm going to turn it over to Lauren, who's going to talk about another addition to the bill.
Hi, everyone. This is Lauren Cabral. I'm an associate with Husch Blackwell. Whoops, we jumped ahead here. Okay, so AB 1335 addresses the collection and retention of data, and it would add the language shown in blue on your screen. There's been some confusion in the past over exactly how long businesses have to retain information and what they need to collect in order to properly respond to consumers' requests for personal information under the CCPA. So this change in Bill 1335 is meant to provide some clarification. It's saying that businesses aren't required to keep information longer than they would in normal business practice, and they're not required to collect anything they would not in their normal business practices. So businesses can build in data minimization principles into their retention programs without running afoul of the CCPA. And then also, AB 1146 made some changes to the right to be forgotten. AB 1146 has language saying businesses don't need to delete information if it's necessary to fulfill the terms of a written warranty or product recall. And that is, the aim of that is, as you can see, safety, just to make sure everyone stays informed. With that, I'm going to turn it back to Bob. Thank you.
Good morning, everybody. This is Ephraim Hentz, associate here with Husch Blackwell. I want to touch on some expansions with the private right of action in the CCPA bill. The first change you'll see in the private right of action is prior to the omnibus bill being enacted, the language with regards to the private right of action had any consumer whose non-encrypted or non-redacted personal information is subject to an unauthorized disclosure has a cause of action against an entity. The omnibus bill has now revised that language to state non-encrypted and non-redacted. So at this point, a consumer whose personal information that is non-redacted and non-encrypted has a private right of action against an entity.
Yeah, and this, before you move on, just, to cut to the chase on this one here, right, it's really difficult to language that they've got here, but this essentially means that if the information is encrypted or it's redacted, that's going to get you out of the private right of action. Before, it could be read because of drafting errors that it had to be both encrypted and redacted to get out of the private right of action. So this is, it's one of these provisions that you have to spend a little bit of time thinking through and looking at and making sure that you've got it right. But this is a good change for businesses as opposed to the alternative.
The next change we're seeing with the private right of action in this bill comes from Assembly Bill number 1130. Assembly Bill 1130 expands the categories of personal information to include military identification numbers, passport numbers, tax identification numbers, and unique biometric data. And since Section 150 of the CCPA links the private right of action to CCPA's definition of personal information, this is the potential liability here has been expanded. Since the categories have been expanded, the potential liability has also been expanded for an unauthorized disclosure. One thing I do want to note at the bottom of this slide, you will see it expands liability on the CCPA's private right of action is that the statutory damages are between $100 or $750 per consumer per incident for an entity that has an unauthorized disclosure. And now let's move on back to Dave to talk about some verifiable consumer requests.
Yeah, thanks, Ephraim. And just on that last slide, just to keep in mind, the CCPA's definition of personal information is incredibly broad, as anyone who's spent time looking at it knows. But that private right of action is in Section 150, as Ephraim mentioned, is tied directly to the data breach notification statute's definition of personal information. And so that subset category of PI that will get you in hot water with data breach, if you have a data breach and with those statutory damages Ephraim referred to, that's been expanded. And it's been expanded for those categories that we just showed you. And so it's sort of one of, again, we talked about those bills that were supplementing the CCPA, not directly tied to it, but it's one of those cross-references you guys pay attention to, because really that could be, I think, in the 3 to 5 year horizon, that could very much be the tail wagging the dog on the CCPA, that private right of action, those statutory damages. I don't think there's any doubt that come January 1st, when this bill goes into effect and the statutory damages go into effect, that there's going to be a cottage industry of class action lawsuits being filed, because now you can get statutory damages and attorney's fees. So it's one of those things where, don't let that slide pass you by. Understanding what data comes into your company and how that relates to the private right of action is a very significant aspect of what's about to happen in 2.5 months. The verifiable consumer request, and then another change that we should highlight is this provision that essentially what this comes down to is, how are you, for the right to access requests, how are you going to receive those right to access requests? And again, this is a pro-business change that they've come up with here. The statute, and it is kind of still a little bit confusing on point, the main portion of it says you've got to have 2 or more methods for submitting requests, and one of those has to be a telephone number. But now there's a sentence after that that says, essentially, if you're a business operating exclusively online with a direct relationship, you're only required to provide an email address. And if the secondary, so that's part A of that revision to the statute. Part B then is, if the business maintains a website, it must also make the website available to submit requests. What I will say is this is going to be an entity-by-entity review of how you're going to receive these requests. Remember, these are access requests. We're not talking about the right to be forgotten. We're not talking about the opt-out. The opt-out is going to be subject to having a logo that the Attorney General's office needs to publish. But this is, a way in which it's supposed to, the CCPA is supposed to become more business-friendly in the context of receiving these requests for access. Another change to the verifiable consumer request provision is this language here, taken straight out of the amendments. The takeaway here is this adding this concept of authentication that's reasonable in light of the nature of the personal information that's requested. If you've been on prior webinars with us, we've talked a lot about this concept of how exactly is it that you are going to verify that the consumer is who they say they are. And this is something that many companies are struggling with right now and trying to figure out exactly how it is that they're going to avoid potential data breach class action damages, right? Because, again, if you're turning over people's personal information and it's not the person who says they are, you've got yourself a big problem because there's statutory damages on the back end there. So, there is, Attorney General's office is supposed to still come up with guidance on these issues, but this concept of adding a reasonability standpoint in light of the nature of the PI requested, I think this creates basically a sliding scale, right? If you're getting your company that's only bringing in limited information like emails and addresses and names, well, verifying somebody's identity to turn that information over to them on an access rights request is going to be much different than if you're an entity that retains Social Security numbers or biometric information. It's 2 different ballgames, right? And what I think is, if you have much more sensitive information, and again, this ties into what we talked about before, that data breach notification statute and the expansion of those data elements there. If you have information that's going to get you in hot water for a data breach, you're going to want to have a higher standard of authentication than if you're just turning over names and email addresses. The privacy advocates argued on this issue that businesses were going to use this as an excuse to set incredibly high standards, for example, requiring notarized requests and things of the like. I don't know that that's going to get to that point, but that is the tug of war to think about on this issue. The second part, I think, here is also incredibly important, which is this addition of this sentence that the business, if you have an account, then you can require the consumer to submit this request through that account. What's not up here, I don't believe is up here, there's another provision in the CCPA which says that you can't force someone to create an account to push through the access request through that account. But if you have an account, if you're one of these companies that sets up accounts for your consumers to buy and sell information or log in, then you can push through the access request through that account. And why is that significant? Because that means that you can leverage existing multi-factor authentication principles or techniques that you have to be able to push that out to these rights to access and the turnover of information. This can be incredibly important to businesses that are really struggling with these issues. Okay, let's switch gears and let's talk about the anti-discrimination provision. Up here are the two changes to the anti-discrimination provision. You might be thinking, wow, I can't believe we're going to spend all this time on changing consumer to business, right, which is essentially what this does. This is one of those instances in which a word has a big significance, and the change of one word can fundamentally change the way in which this anti-discrimination provision is implemented. The big tug of war that was occurring over the last few months was how the anti-discrimination provision, basically what that is, for those unfamiliar, is the CCPA has this concept in it that you can't discriminate against people for exercising their rights, okay? But the struggle became, well, how does that apply to things like customer loyalty programs? And so there was a specific bill that was proposed that would have exempted customer loyalty programs entirely from this anti-discrimination provision, with some caveats, of course, right? That did not get it across the finish line. We'll talk about that in a minute. That bill was withdrawn by the author. However, the privacy advocates are saying that this change here from consumer to business has the effect of essentially getting those customer loyalty programs outside the anti-discrimination provision clauses, right? And so let's just look at the language on the very bottom sentence. Reads a business may also offer a different price, rate, level, or quality of goods or services to the consumer if that price or difference is directly related to the value provided to the business by the consumer's data. And instead of saying the value provided to the consumer, it's the value provided to the business. So why does that matter? Well, that means, if you go into your grocery store and you are a member of their loyalty club, and they have one price for members of the loyalty club and one price for members who are not part of the loyalty club, that essentially is being said by privacy advocates that this change here has made that okay under the CCPA. Frankly, the way it was written before didn't make any sense, right? The use of the word consumer didn't make any sense, and I think privacy advocates will say, yeah, we get that this was a typo. We understand that this was an issue that was, because of the rushed nature of the legislation, really should have been fixed before it got across the finish line. However, given this change right here, this was a very minor change, one word that has incredibly significant impacts for those entities that are operating loyalty programs. This is something you're really going to want to think of and really want to take a look at. All right, let me turn it back over to Bob to talk about the AG regulation change.
Yeah, so one additional item that the legislature assigned the Attorney General or gave them the ability to adopt regulations and establish rules and procedures on how to process and comply with verifiable consumer requests. I think the previous legislation had the AG providing advice on the form in which those verifiable requests would be received. This actually goes a step further, I think, which is good, which should provide direction for businesses governed by the CCPA and how to set up a program in order to receive and to respond with these requests, which the Attorney General would consider be compliant with the law. One of the notable items is that in the initial listing of items that the AG is charged with providing advice or regulations on, this section was added in a separate section. We are interpreting that to mean that because the prior 7 items that were listed directed the AG to submit draft regulations for public input, that the inclusion of this in a separate section may allow the AG to just kind of introduce these by fiat as opposed to requiring public participation and input on these regulations. Another small change, and it might not apply to everybody, but I know there are a few people on here who probably does apply, is that the CCPA, really the initial draft, very highly heightened the requirements for companies offering services, at least, well, generally, I guess, to children under 16 years of age. You know, federal law, the CCPA law, applies to children under 13, and so what the legislature here did was they changed the requirement so that if you have actual knowledge that you are providing goods or services or collecting personal information of consumers less than 16 years of age, for consumers that are 13 to 16, you have to get their actual consent, and for children under 13, you have to get affirmative consent from the parent or guardian, which that last part is consistent with the federal CCPA law. But it's kind of interesting here that the legislature is appearing to allow children 13 to 16 to provide legally binding consent related to the use of their personal information. I'm going to kick it back to Dave here to talk about some other changes, more of a high level.
Yeah, thanks, Bob. And this is sort of our, grab bag of other stuff that changed in the bills. The first two are, if you're a consumer reporting agency or you happen to be, in the motor vehicle dealer manufacturer context, you're going to want to take a look at the language that's changed with respect to those. The consumer reporting agency exemption language changed. It's enough to look at it. It was intended to broaden it, be more business friendly. We're not going to dig through it, given that it's sort of a limited issue to that group of individuals and businesses. However, it's there, and if it's relevant to you, take a look. And the same thing with the motor vehicle. We're not going to dive into the exemption language there, but it's relevant to you. You know it exists, and take a look. Number 3 is they've modified the online privacy notice disclosure obligation. So, for those of you familiar with the CCPA, you know that there's provisions in there that require you to have an online privacy notice that is consistent with pre-existing California law, CalAPA, and Shine the Light law has certain requirements in that respect as well. And the CCPA has provisions in there that modify what you're going to need to say. They've added a couple sections to that. They've added sections 100 and 105. So essentially, you're going to have to be able to describe to California residents in your privacy notice those rights that are under 100 and 105. 105 is the right to be forgotten section. 100 is the introductory section to the CCPA. But anyway, I want to sort of, at that point in time, caveat that by saying that the AG's office, and Bob's going to get into this towards the end, is going to have regulations on what the notice is, should say, in the format, those types of things. At least we're hoping that they will. It's one of the items. And so, in any respect, it's something to keep in mind as you're driving compliance, that there's been a change there to the online privacy notice. And similarly, that trickled down into the expanded training requirements. There's a provision in the CCPA that essentially requires that if you've got individuals who are going to be receiving consumer requests, they got to be trained on certain things. And these provisions, 100 and 105, are now part of those training requirements as well. And finally, number 5, there's a number of grammatical errors and cross-reference errors that they've tried to clean up throughout, you would all log off if we went through all the grammatical errors they were trying to change and the cross-reference errors. But it'll be, to the extent that you've got compliance obligations here, you're driving into compliance with your organization, it's something you probably just want to eyeball and make sure it doesn't impact anything that you're doing. With that, I want to talk about a separate statute. Turn it over to Ethan. He's going to talk about 1202.
Thanks, Dave. Let's now discuss the Data Broker Registration Amendment to the CCPA. Assembly Bill 1202 now requires data brokers to register with the California Attorney General. Assembly Bill 1202 also has, if a data broker fails to register with the California Attorney General and provide certain information, the Attorney General is in charge of enforcing actions. It can assess the broker's civil penalties, fees, and costs that can ultimately reach about $100 per day. Now, you're probably wondering how the Assembly Bill 1202 defines data brokers. The bill defines data brokers as a business that knowingly collects and sells to third parties the personal information of the consumer with whom the business does not have a direct relationship with. This is, as there's been talk that this bill is a backdoor way to have all businesses register with California. This is simply not true. The reason for this requirement is that unlike traditional businesses where a consumer might have some knowledge of the business's control over the consumer's personal data, consumers usually are not aware or have not had any contact with a data broker who's possessing their personal information. The legislative intent of Assembly Bill 1202 also narrows down this requirement for data brokers to register, and it really just boils down to if a consumer does not have direct relationship with a data broker, then it is a data, or with an entity, then it is a data broker and must register with the California Attorney General.
Yeah, and just sort of to give a little more flavor on that. So this was sort of a surprise that AB 1202 got passed. We went to sleep on Friday night, and it looked like this bill was dead, and then woke up in the morning, and there it was. There's been, in the initial, over the weekend, reporting on this, there's been a lot of discussion that somehow if you are a business under the CCPA and you sell consumer personal information, and remember, a lot of entities have looked at that definition of sell and realize, hey, I'm covered by this. The CCPA defines sell very broadly, right? And it essentially is a transfer of PI to a third party as opposed to a service provider. And so there was some discussion over the weekend of, well, somehow this is going to require any entity that sells to third parties, as the CCPA defines, to register with the Attorney General's office and pay a registration fee and get fined $100 a day if they don't. I think what is missing from that discussion is that this, as you see right there, it says with whom the business does not have a direct relationship. And if you go to the bill and you look at Section 1 of the bill, there is a lot of discussion about what direct relationship means. And it didn't make its way into the exact definitions of it, but there's a lot of context there, and you can't just let that context be lost, right? And there's also a lot of discussion about what a data broker is, and it's what you would think it is. It's an entity that collects a lot of information from a lot of different areas, from a lot of different data points and companies, puts them together and sells it to third parties, right? So my concern is over the next few days, there's going to be a lot of articles written about this AB 1202, and I think everyone should keep in mind that there is provisions in there that explains direct relationship. I do not look at this as some sort of bill that's going to require entities across the country to register with the AG's office. And if there's no, to put a finer point on it, right, it has a definition of data broker. If it wanted businesses to sell, to register under the under the CCPA, it would have just said businesses that sell. It wouldn't have created a new data broker category. It would have been a really easy way to get it across the finish line. So anyway, just one of these things to keep in mind if you see the articles get written or blog posts that get written over the next few days on these issues, just think about it and think about it in light of this discussion. Let me hand it back over to you to talk, lead us off on what didn't change.
And now let's look at what didn't change.
Oh, sorry, it's back to me. I didn't realize that. So, okay, so what didn't change? We talked about this before, 846, the customer loyalty programs. So This would have amended, would have interplayed, I should say, with the CCPA's anti-discrimination provision. There was a lot of talk that this would have gotten across the finish line, and it looked like it. Frankly, I mean, it looked like it last week that it would get across the finish line, and it didn't. But there was that change that we talked about, the change from consumer to business, that a lot of privacy advocates are pointing at as essentially, getting companies what they wanted without having to have 846 get across the finish line. There's also the talk as well that 846 will get resurrected next year, and that the business advocates will continue to try to push for legislation that excludes customer loyalty programs from the CCPA. Also, two other bills that had exemptions, 1416 and then Senate Bill 753, did not pass. They never really got very far. In particular, 753 would have created new exemptions to the definition of sale. We talked about that in prior webinars. It really is something worth keeping in mind and understanding the nature of what didn't pass, because they were trying to get after relationships with third-party advertising cookies and create an exemption to sale for that, and it did not pass. So you can take from that, if something was to be excluded and it didn't get across the finish line, then it's covered. And the story really there was that Alistair McTaggart, who was one of the primary driving forces of this bill, the CCPA, looked at that 753 and said, "My God, this is exactly what this is supposed to cover. We're not going to exempt this information." So again, some things that businesses were pushing for that did not get across the finish line. Bob, let me turn it over to you to talk about 873.
Yeah, thanks, Dave. So AB 873 was an attempt to provide some clarification as to what de-identified means under the statute. The proposed amendment submitted a definition of de-identified that tracked the definition that is currently used by the FTC. And so this rejection of this amendment potentially raises the issue that there will be two standards of what de-identified means in relation to consumer privacy law. So we'll keep our eyes on that and see how that develops. AB 1760 was a Privacy for All Act. This seemed a very privacy rights friendly amendment, and that it basically tried to tie the rights that were granted under this provision to the constitutional right of privacy that Californians adopted into their constitution. It had some very restrictive requirements as to businesses' obligations that were even more strict than what the law currently has. I think it's a good thing for all of us that was not adopted. Now I'm going to hand it over to Lauren to talk about the next proposed bill that didn't get passed.
AB 981 dealt with the insurance institution exemption. This bill would have eliminated a consumer's right to request a business to delete or not sell the consumer's personal information under the CCPA if that information was necessary to retain or share to complete an insurance transaction, and that one did not pass. I'll pass it back to the team for SB 561.
So SB 561 would have expanded the private right of action to cover all of the CCPA's privacy rights. This bill did not make it out of committee. This bill would have expanded, as I mentioned, would have expanded the private right of action to all CCPA's privacy rights, such as the right to opt out, right to be forgotten. But now the private right of action only applies to any unauthorized disclosure of personal information. Next, let's take a look at some bills that are related to the CCPA. This would be AB 1035. This bill also did not pass. This bill would have defined reasonable security procedures and practices that an entity would have had to implement to conform to the specific standards published by the National Institute of Standards and Technology. This bill, again, did not pass. And so now you just need to be familiar with the reasonable security procedures that the CCPA outlines.
Yeah, maybe I can speak to that a little bit. I mean, this is one of these issues that really could have helped businesses if AB 1035, as originally drafted, got across the finish line. We've been talking a lot about this private right of action, right, which really, I think, again, is going to become significant come January. It says that you can be sued for a breach due to the failure to implement and maintain reasonable security standards. There is no definition of what constitutes reasonable security standards in California law. There's guidance that says 20, provides some guidance, but this becomes, a negligence standard, essentially. And as originally drafted, 1035 would have linked reasonable security to NIST standards. It never really got anywhere. And it's indicative of this struggle I think companies are really going to have to get after now as to developing information security programs and security standards because, listen, breaches can happen. And breaches can happen having nothing to do with the fact that you have not implemented reasonable security. But I think, attempting to drive after compliance with the standard, looking at states like Ohio that have created safe harbor provisions, is something that you really want to think about when you're driving compliance with the CCPA. Do not forget about the private right of action. I think, Lauren, you're going to talk about AB 288. Is that right?
Yes. AB 288 would have required social networking services to give users that close their accounts the option to have the user's personally identifiable information permanently removed from the company's database and records, and it would have prohibited the service from selling the information or exchanging it with third parties in the future, subject to specific exceptions for things like detecting security incidents or debugging errors that impaired existing functionality of the sites. That bill died very quickly. And then AB 1281 would have required a business in California that uses facial recognition technology to disclose that usage by posting a physical sign at the entrance of every location using the technology. The sign would have been required to include information about where people could find information about the purpose for which the business uses that facial recognition technology. That bill didn't pass either. I'll turn it back to the team for AB 950.
Yeah, so finally here, AB 950 was a bill I think we can all be thankful did not pass. It required businesses to disclose to consumers the monetary value of the consumer data that they've collected to the business. I think we can all realize that that is almost an impossible task. So not only would you have had to come up with some sort of measure that assigned a monetary value to the value of the information you're collecting, it also required you under the statute to update that every 90 days. So I think we're all thankful that this one didn't get through. So now we'll move on. What comes next?
Yeah, and Bob, before we do, I thought maybe sort of just put a bow on everything that everybody's been talking about is, and Bob's about to segue into sort of what we're going to see from here. But the takeaways really are, I think, that the fundamental rights of the CCPA remained intact. There's some discussion of the anti-discrimination provision and how that's going to play with that change there. But the fundamental rights of the CCPA remain intact. And if you look at the reports and the press releases of privacy advocacy groups, that's really what their takeaway is, right? There was attempts by business over the last year to be able to weaken and reduce the obligations under the CCPA, and by and large, they were resisted. The counterpoint, though, is that businesses and business advocacy groups, their press releases over the weekend, focused on the fact that there is the addition of the word reasonably, the definition of personal information, which is something that can be very helpful to businesses as they're trying to drive compliance. The employee exemption and the business-to-business exemption, as Bob indicated on the business-to-business, I mean, this was really one that frankly took me by surprise that got across the finish line. That there was really no draft legislation on that until the very last minute, and that got across the finish line. It was behind the scenes, highly negotiated, but again, privacy advocates will point to those two and they'll say, okay, well, you've got 1 year, right? And so, it's one of these things where I think you look at it and you look at the 19 bills that we started with at the beginning, and you look at where we are today, and there was a heck of a lot of stuff that went on in committee hearings and articles that guys like us wrote, interpreting and reading the tea leaves and all that type of stuff. But this is what we have. We have a largely intact bill with some pro-business exemptions, and the business wanted more and privacy advocates wanted more, but we got what we got, and we can move on to what comes next.
All right, so what comes next? So the first thing we're expecting is the governor will review and sign these amendments. So as soon as that happens, and these will be officially become law, we expect that kind of in the next 2 to 4 weeks, next few weeks, and I'm sure we'll update that on our blog when that happens. So the fall of 2019, I think after the governor signs this, which there doesn't seem to be any indications that he won't, the Attorney General is has told us that they're going to implement some draft regulations. That's their target, is to get that out this fall. Attorney General final regulations will probably end up happening sometime after the first of the year, after the effective date of January 1, 2020, where the bill goes into effect. And then the Attorney General will start enforcing the bill 6 months after the publication of the final regulations, or July 1st, 2020, whichever is sooner. What we're expecting from the Attorney General regulation is really further direction and clarification on 7 key items for compliance. And once these are issued and we get the draft, kind of what the AG is thinking, we'll be in a much better position to provide real substantive advice on actual compliance with these sort of elements. Again, categories of personal information, definition of unique identifiers, exceptions to the CCPA, some clarifying language regarding that, submitting and complying with requests, a uniform opt-out logo button that's going to describe what you're going to need to have on your websites or at your point of sale in order for people to opt out. Notices and information to consumer, including financial incentive offerings, verification of consumer requests, and then the 8th element is what we talked about earlier, further directions on how businesses can comply with answering verifiable requests. Pass it over to Ephraim to discuss, what you should be doing right now.
Thanks, Bob. So as Bob mentioned, your question for us is probably what should you be doing right now? Well, the first step is to analyze your organizational chart. You need to understand how the CCPA defines a business. Under the CCPA, they define a business as any subsidiary or entity that's using common branding or is commonly controlled by a hierarchy or by an organization. So the purpose here, if you have any entities or subsidiaries that you have common branding with, or you are commonly controlled from one principal office, that is going to be a business under the CCPA. Next, you need to look at the inventory. You need to inventory your data. You need to understand, chart what personal information you're collecting from California consumers. Next, determine your web presence. You need to make an inventory of your websites. You need to understand how many privacy notices you will need to draft in the future per website. Fourth thing you need to look at is understand how your organization is using cookies. The CCPA will cover cookies usage, and so you will need to know what cookies you're using and what information you're collecting from those cookies. And finally, information security. This dovetails into the California consumer's private right of action. You need to implement reasonable security measures to make sure that the personal information you are collecting is secured and avoid any data breaches.
Yeah, thanks, Ephraim. And I think, number 3 in particular there, when you're talking about the web presence issue, right, I think what we're trying to drive after on that aspect is organizations can have, and we've seen it with a number of our clients, can have many, many websites. It's not just, your company's name.com. There's other websites that your marketing teams have stood up for their own purposes or for, related entities, things of the like. And it's a really time-sensitive type thing to be able to grab all of those and to understand what they're collecting on those websites and whether the privacy policies, because remember, we talked about it before, that you have to have an online privacy policy. There's requirements as to receiving requests and opt-out logo, like Bob was just talking about. So this needs to kind of be looked at on a website-by-website basis, and whether or not you can be using the same privacy policy across multiple websites, tie those together, or if you need to have separate ones. And really, there's the decision-making process for that can take a fair amount of time to go through that. And this is something, if you're waiting for the AG regulations to come out, it's going to be a challenge to get that across the finish line, right? And on the inventory, your data and third-party transfers, Husch Blackwell has developed a tool to do that. It's something we're very proud of, frankly, and essentially how it rolls out is it's an online client portal. We've taken, the Husch Blackwell CCPA guidance and our knowledge base of this, turned it into a question and answer format, and allows us to map, to inventory data in connection with the CCPA data elements and third-party transfers, and to really get after exactly what it is that the CCPA requires you to be able to say to individuals on your online privacy notices and et cetera. This is all, based upon the statutory references, and it's all a very easy interface that allows us to quickly and efficiently do this with our clients. It's a shameless plug, right? But it's offered to our clients for a reasonable flat fee. And I think the caveat is that law firms are really trying these days to, well, if they're not trying, they should be, to really reinvent themselves to be able to leverage technology in a way that meets our clients' needs. And this one allows us to significantly reduce our attorney's fees and internal client time, because you know exactly what you're getting, you know why you're collecting that information. In any respect, if that's of interest to you, it's a pretty significant tool. If that's of interest to you, just feel free to email one of us, and we'll be happy to set up a demo for you. Finally, the other bill that is a couple weeks from implementation is Nevada. For those of you who have tracked the bills that came out, I mean, essentially, as the story goes, the CCPA gets enacted last June, it gets revised in September, and when the legislative sessions opened, there was a flurry of other states that proposed legislation in the wake of the CCPA. Some of them were copy and paste bills. Some of those were fundamentally different, like the Washington Privacy Act in the state of Washington. By and large, none of those statutes actually got across the finish line, with one exception, and that's Nevada. And Nevada has an existing online privacy statute, disclosure statute, and that is very similar to CalAPA and California's existing online privacy statute. They originally went in there and they tried to make it an opt-out provision that would be opting out of sales, and it would be enforced by a private right of action, really significant. It got watered down along the line, and eventually what did get enacted is an opt-out provision. But the definition of sale is really linked to what you would, it's similar to kind of like the data broker definition. I'm not going to say it's a one-to-one comparison, but and this, frankly, it's copied and pasted right there. But it's a whole different definition of sale than is under the CCPA. Notwithstanding that, the Nevada legislation can be read to require you to receive verified requests to be placed, even if you're not selling information, be placed on a list, I guess in case the company ultimately decides that it's going to sell information. It's not a CCPA. I don't want to tell you that it is. However, it goes into effect October 1st, and it's something that really I think you should be taking into your consideration. I mean, if you're going to get this right, you should probably get it right across the board. I don't think it's going to be a heavy lift from those clients on this aspect, but it's something to think about. All right, so then, the last slide, the other shameless plug for this program is we've got a blog, and we track all these things. We write, we update about this legislation, not just on CCPA, but all things related to privacy and cybersecurity. I encourage you to take a look at that. If this is of interest to you, please subscribe. We'd be happy to have you. With that, everyone, our time is basically exactly up. So we will note that there are questions that have come in, and again, given that we're over our time right now, we'll go ahead and handle those questions afterwards and send you guys emails. Really do appreciate you all attending today, and look forward to talking to you all in the near future. Thanks.